Hello and welcome to PERB's 50th anniversary celebration webinar. My name is Sheena Farrow. I am a senior attorney in PERB's Office of the General Counsel, and I'm going to be presenting today's material, which is a training on general labor law principles. Today's discussion is going to be a general overview of basic labor law principles that are present in many of the statutes that the Public Employment Relations Board, or PERB, administers. This includes collective bargaining statutes covering employees of California's public schools, colleges, universities, the state of California, local public agencies, trial courts, certain transit agencies, and the Judicial Council. While PERB's jurisdiction extends beyond these public employees, we are going to focus today on the general legal principles in the most common statutes administered by PERB. Before we begin, please note that the views expressed in this presentation are those of the presenter and are not PERB's official position on any matter. This content is for general informational purposes only. This information is not legal advice. Some statutes that PERB administers have unique characteristics that may differ from the general principles discussed here. Please refer to the specific statutes, regulations, precedential decisions, or other legal authorities as appropriate. Although we will not be fielding any questions today, you may send any questions about this material or about PERB's process to perb@perb.ca.gov. Let's begin. When discussing labor relations, it's helpful to remember that the overarching purpose of collective bargaining statutes is harmonious labor relations, and this is achieved by balancing the rights and the obligations of employers, employees, and unions. So with that in mind, today we're going to discuss the general rights and obligations that employers, employees, and unions have under the acts PERB administers, specifically employee rights and protected activities, exclusive representatives' rights and duties, employers' duties, and a violation of these duties that we're discussing today are commonly called an unfair labor practice, and common unfair labor practices. We'll begin by discussing protected employee activity. There is a wide range of protected employee activities. Here are some examples of many types of protected employee conduct. Employees have the right to form, join, and participate in the activities of an employee organization of their choosing. Employees also have the right to refuse to join or participate in activities of employee organizations. Employees have the right to represent themselves individually in their employment relations with the employer. Employees also have the right to serve as a union officer, a bargaining team member, or a union steward. Employees have the right to peaceful, non-disruptive picketing, to wear or display union insignia, and to distribute literature or solicit union membership. Employees also have the right to seek assistance from their union or from their coworkers, to assert rights under a collective bargaining agreement, or to file grievances and unfair practice charges. Employee speech is protected when it is related to a legitimate labor and employment concern, such as discussing working conditions, criticizing management, or criticizing union leadership. There is leeway for behavior that is impulsive or intemperate, but the board has provided that speech is not protected if it is so opprobrious, flagrant, insulting, defamatory, insubordinate, or fraught with malice as to substantially disrupt or materially interfere with employer operations. Employee strikes or work stoppages can be protected conduct when they're an unfair practice strike, or they're also called ULP strikes, or an economic strike, which occurs after a bargaining impasse and exhaustion of impasse procedures, or a sympathy strike. However, there are exceptions to the right to strike when a valid contract contains a no-strike clause, or if a strike is a wildcat strike, a surprise strike, or intermittent strikes, or if a strike includes employees whose absence creates a substantial and imminent threat to public health or safety. These are commonly called essential employees. Employees have the right to union representation in certain types of meetings with their employer, which are investigatory meetings, often called Weingarten meetings, meetings under highly unusual circumstances, grievance meetings, or meetings that are a part of the interactive process related to disability accommodations. The right to union representation does not apply to meetings that are run-of-the-mill shop floor conversations, or meetings where an employer is informing an employee of disciplinary action that has already been decided on. And there are some limitations to the right of union representation in meetings. Specifically, even when an employee is entitled to union representation in a meeting, they are not entitled to the individual representative of their choosing, and they are not entitled to unreasonably delay the interview. So you might be thinking, how does an employee trigger the right to union representation in a meeting with their employer? Well, the employee must make an affirmative request that places the employer on notice of their desire for representation. The employer may then grant the request, discontinue the interview, or offer the employee the choice of proceeding with the interview without union representation or having no interview at all. The employer cannot ask the employee to supply a written statement regarding the matter instead of submitting to the interview. An employer is obligated to allow meaningful representation. This means that the employer must provide sufficient time and information to the union regarding the alleged wrongdoing prior to the interview to allow meaningful representation. And also, the employer must allow private consultation between the employee and the representative before the interview. The employer cannot prevent the representative from speaking at all, but it can limit questions to the scope of the interview. With all of that in mind, a Weingarten violation is established when the employee requested union representation for an investigatory interview, the employee reasonably believed the meeting could result in disciplinary action, which is an objective standard, and the employer denied the request and continued the meeting. Now, let's turn to union rights. Unions have the right to represent their members in their employment relations with the employer. Unions have the right to access non-work areas during non-work times to distribute literature and solicit membership. And unions have the right to access the employer's means of communication, such as bulletin boards and email systems. Unions also have the right to access work areas under certain circumstances, to represent members in meetings and over grievances, and to release time for employee representatives engaged in formal meeting and conferring with the employer, testifying or appearing as the organization's representative in PERB unfair practice proceedings, or testifying or appearing as a representative before a personnel or merit commission. Unions also have the right to directly advocate to the employer's top officials, to access new employee orientations, and to regularly receive employee contact information. Let's discuss the union's duty of fair representation. The exclusive representative has a duty to fairly represent all employees in the bargaining unit that it represents. This duty applies in contract enforcement in stages where the union controls the employee's grievance rights. This duty also applies in collective bargaining. It means that the union must refrain from acting in a manner that is arbitrary, discriminatory, or in bad faith, but the union is afforded wide discretion in contract negotiation and processing grievances. Let's turn to one of the most important aspects of labor relations, the duty to bargain in good faith. An employer and the exclusive representative have a mutual obligation to meet and confer in good faith regarding wages, hours, and other terms and conditions of employment. The scope of representation is a phrase that refers to matters that are subject to bargaining. Mandatory subjects include wages, hours, and other terms and conditions of employment. Some examples of mandatory subjects are pension benefits, health benefits, telework policies, evaluation procedures, disciplinary procedures, and health and safety concerns. Permissive subjects are subjects of mutual interest to the parties. Examples include layoffs or fundamental public policy decisions. Prohibited subjects are illegal or preempted by state or federal law. Examples of prohibited subjects are requiring promotion of the most senior applicants or teacher tenure requirements. For mandatory subjects of bargaining, the employer must provide the union with notice and an adequate opportunity to bargain before taking action to change a matter within the scope of representation. If bargaining is requested, the parties must bargain until they reach either an agreement or impasse. Permissive bargaining subjects are those which the parties may mutually agree to bargain over. They are neither mandatory nor prohibited. There is no duty to bargain if either party declines, and permissive subjects cannot be insisted upon to impasse. Even when a particular decision is not a mandatory subject of bargaining, the employer must provide notice and an opportunity to bargain over any reasonably foreseeable effects the decision may have on matters within the scope of representation. This is called an effects bargaining obligation. Generally, notice and opportunity to bargain must occur before the policy takes effect. So what is impasse? If the parties reach a point where further negotiations would be futile, they are at impasse. Some statutes, such as the MMBA, ERA, and HERA, provide for fact-finding after the parties reach impasse, and parties may participate in mediation prior to fact-finding. After reaching a bona fide impasse and completing any applicable impasse procedures, the employer may impose its last, best, and final offer. Now let's turn to breaches of the duty to bargain in good faith. PERB generally applies one of two standards to determine whether a party breached its duty to bargain in good faith: the totality of the circumstances test and per se violations, which are acts that in and of themselves constitute violations of the duty to bargain in good faith. The totality of the circumstances test examines whether the totality of the respondent's conduct was sufficiently egregious to frustrate negotiations. Examples of conduct that indicates bad faith bargaining are failing to respond to proposals in a timely manner, engaging in dilatory tactics, making regressive proposals, making predictably unacceptable proposals, failing to adequately explain proposals, making a time-limited offer without a legitimate basis, unilaterally setting a time limit on negotiations, rushing to impasse or prematurely declaring impasse, or engaging in other unfair labor practices during negotiations. A party is permitted to maintain a hard bargaining position on one or more issues if the entire course of its bargaining conduct, both at the table and away from it, manifests a good faith effort towards reaching an overall agreement. Per se violations of the duty to bargain in good faith are unilateral changes, bypassing the exclusive representative, which is also referred to as direct dealing with employees, or failing to provide requested information. A unilateral change violates the duty to bargain in good faith when the employer takes action to change policy, the change in policy concerns a matter within the scope of representation, the action was taken without giving the exclusive representative advance notice and an opportunity to bargain over the change, and the action is not an isolated incident that is unlikely to recur, but amounts to a change in policy. This last point is often referred to as having a generalized effect or continuing impact on terms and conditions of employment. Direct dealing or bypass may occur in two ways: by directly approaching employees to effect a change in matters within the scope of representation, or by communicating directly with employees to undermine or derogate the exclusive representative's authority to represent unit members. Let's discuss requests for information. The exclusive representative has a right to information that is necessary and relevant to its representational duties. This is a very liberal discovery type standard. Information immediately pertaining to a mandatory subject of bargaining is presumptively relevant. There is a violation of the duty to bargain if the employer responds to a request for this information by ignoring the request or outright refusing to provide the information, unreasonably delaying in responding, or responding conditionally. Let's discuss defenses to providing requested information. Waiver, privacy, undue burden, or privilege must all be raised in response to the request. If a request requires clarification, is unduly burdensome, or seeks private information, the responding party must offer to bargain in good faith regarding an appropriate accommodation. The employer does not need to provide information in a form more organized than its own records, but it may be required to compile information that is not contained in existing records. Additional defenses to providing requested information are: the employer does not need to provide information that does not exist. The employer does not need to provide information that is equally available to the union, but it may be required to point out where to find it. However, it is important to note that Public Records Act exemptions are not valid defenses to producing information requested pursuant to the acts that PERB administers. That concludes our discussion of violations of the duty to bargain in good faith. Let's turn now to discuss a common unfair labor practice, which is retaliation or discrimination. A prima facie case is established by showing that an employee engaged in protected activity, the employer had knowledge of the protected activity, the employer took adverse action against the employee, and the adverse action was taken because of the protected activity. This is also referred to as unlawful motive. For adverse actions, PERB uses an objective test to determine whether an action taken is adverse. An action is considered adverse if a reasonable person under the same circumstances would consider the action to have an adverse impact on the employee's employment. Examples of adverse actions include suspending an employee's employment, placing an employee on involuntary leave, docking their pay, providing a negative evaluation, threatening to terminate employment, initiating a disciplinary investigation, issuing reprimands or written warnings, or placing documentation that could support future discipline into a personnel file. Let's discuss facial discrimination. Unlawful motive in a retaliation or discrimination case can be proven either by direct evidence of unlawful motive or with circumstantial evidence. In cases where an employer's conduct facially discriminates based on protected activity, that's considered discrimination in its simplest form, and PERB may infer unlawful motive without additional evidence of motive. Examples of facial discrimination include providing different pay, benefits, or working conditions based explicitly on union membership or other protected activity, or changing policies in response to protected activity. In cases where there isn't direct evidence of unlawful motive, motive can be proven with circumstantial evidence. PERB considers close timing as relevant but not determinative, and will consider additional circumstantial evidence such as disparate treatment of the employee, departure from established procedures, inconsistent or contradictory justifications for the employer's actions, a cursory investigation of the employee's misconduct, offering exaggerated, vague, or ambiguous reasons, employer animosity towards union activists, or any other facts that demonstrate unlawful motive. There is an affirmative defense to retaliation or discrimination. Once a prima facie case is established, the burden shifts to the employer to demonstrate that it would have taken the same action despite the protected activity. The charging party can overcome this defense by demonstrating that the reason is pretextual. Another common unfair labor practice is interference with protected activity. Employers are prohibited from interfering with, restraining, or coercing public employees because of their exercise of rights guaranteed by the various labor relations acts. Typically, this occurs through threats, directives, or rules that restrict protected activity, or surveillance of or questioning about protected activity. To establish a prima facie case of interference, the charging party must show that the conduct tends to or does result in at least slight harm to employee rights. The charging party need not establish an unlawful motive or that any employees were actually deterred from engaging in protected activity. There is a free speech safe harbor for employers. Statements of opinion are protected as long as they do not include a threat of reprisal or a promise of benefit. The affirmative defense to interference involves a balancing test. If the harm to the employee's rights is slight, then the employer must demonstrate operational necessity and the competing interests are then balanced. If the harm is inherently destructive of employees' rights, then the conduct will only be excused if it was occasioned by circumstances beyond the control of the respondent and no alternative course of action was available. Employers are prohibited from dominating the union, which refers to being involved in union activities, including favoring one employee organization or internal union faction over another, dominating or interfering with the formation or administration of an employee organization, or contributing financial or other support to an employee organization. The prohibition on public employers deterring or discouraging union membership, which is referred to as the PEDD for short, applies to most of the employers under PERB's jurisdiction. The PEDD prohibits a public employer from deterring or discouraging represented or unrepresented employees or applicants from exercising free choice in deciding whether to authorize representation, become or remain a union member, or commencing or continuing to pay union dues or fees. When analyzing such a claim, PERB considers all relevant context. Relevant contextual factors include, but are not limited to, the truthfulness or misleading nature of a communication, the necessity for the communication and whether the communication was narrowly tailored to that necessity, the mode, timing, frequency, and duration of the communication in question in comparison to other employer communications, and the employer's good faith motive or animus. The PEDD also requires that if a public employer wishes to disseminate a mass communication concerning exclusively represented employees' rights to join or support an employee organization, or to refrain from doing so, that before sending such a communication, the employer must meet and confer with the exclusive representative regarding its content. If the parties do not reach agreement and the employer still chooses to disseminate the communication, then the exclusive representative has the right to draft its own communication and have the employer disseminate the two communications together. This concludes our overview of the most common unfair labor practices, protected activities, and duties under the statutes that PERB administers. We hope you found this overview of general labor law helpful. If you would like additional information, you can access the statutes that PERB administers, PERB's regulations, and precedential board decisions on PERB's website at www.perb.ca.gov. If you have any questions, including those about PERB's procedures and the resources available, please send them to perbquestions@perb.ca.gov. Please join us next month for a webinar presented by the State Mediation and Conciliation Service, which will provide an overview of the many services that they offer. Thank you for watching.